Welcome to this free immigration help channel. Today is March 30, 2023, and we are getting into the volume 47 of me answering your questions, your immigration related questions, and all of your comments. So before I begin, as always, I'm going to mention I'm not an immigration attorney. This is not a legal advice. All the information that I provide in these videos on this channel are directly from official government sources like USCIS.gov and of course the Department of State. So without further ado, let's start with the very first question comment from Namra Hurshid. And I'm sorry if I'm mispronouncing the names. Hello, I am a US citizen and applied for my spouse. Priority date is September 2020. I have sent expedited requests to NVC a couple times and they say the case is documentarily completed and nothing needs to be done. Please tell me how long I can expect. Very difficult situation. I'm very sorry, Namra, you're experiencing this, and it does sound a little bit weird because whenever it comes to US citizens petitioning for spouse, there is no immigrant visa cap for that specific category because it's an immediate relative of US citizen. So once NVC documentarily qualified your petition, they should have transferred it, and usually they do it within about 30 days. They transfer it to the local US embassy if you're beneficiary or if you are a beneficiary and are outside of the United States. Or obviously if you are in the United States, probably the process would have been different. So I'm assuming the beneficiary is outside of the United States. So I'm gonna ask you if you can follow up with a separate comment. Do not respond to my comment here, and I'm gonna post this so that you're aware that I addressed this. Do not respond to this comment, just post as a separate comment, because if you do respond it, and it goes for everyone who's watching this video, for some reason YouTube does not send me those notifications. I don't know why, but they don't. But let me know when you were documentarily qualified with NVC. One thing that I wanted to say is it's a little bit weird why they responded this way, NVC, because usually whenever it comes to requesting the expedited processing with NVC, two requirements that have to be met, and you meet both of the requirements. The first one is that the case has to be documentarily qualified. You can't really request NVC to process your case faster if it is not yet documentarily qualified. That's the thing. That's one of the requirements that they themselves list on the Department of State website. And another requirement is that the immigrant visa has to be available for your case, which we know it is because you are in the priority category that does not have a visa cap at all. So I want to know, I'm really interested to know when you were documentarily qualified. Like I said, usually, if you were just recently documentarily qualified, like a month ago, I would give it another month just to see, because it does take some time for NVC to transfer your case to the local US embassy. And then it does take some time for the US embassy to schedule the interview, depending on the availability of the time slots for the immigrant visa interview. So if you could follow up, that would be more helpful, and I would be able to provide a little bit more information. On the plus side, you don't have to worry about the visa bulletin at all. Why? Because there are no visa caps for your category. So you're not waiting as part of the backlog that a lot of people are experiencing with the visa bulletin. All right, let's move on to the next comment from Ayokunmi Akano. And I'm very sorry if I mispronounced the name. Thank you very much, Ayokunmi, for being publicly subscribed to this channel. Hi, I'm a US citizen. It's been 15 months since I filed for my wife. Any advice on what I can do? I checked the USCIS portal and it says cases being actively reviewed. Also, what category do I fall on? Thanks. Okay, Ayokunmi, again, good news for you is that you don't have to deal with the visa bulletin whatsoever, because there are no visa caps on the immigrant visa specifically for spouses of US citizens. Whenever it comes to the category, it's going to be CR1, but it has nothing to do with the visa bulletin, because visa bulletin is specifically for those categories that are waiting for the immigrant visa to become available for their category. All right, and you don't have that at all. So the immigrant visa, once your petition is approved, by USCIS, your immigrant visa is already available. The only thing that you'll have to do, obviously, go through the get documentarily qualified with NVC. But then again, it depends if you're petitioning for your wife, if she's here in the United States or if she's outside of the United States. If she's here in the United States, then you don't even need to bother with NVC because the processing is going to be different. But if she's outside of the United States, then you would have to log into the NVC portal, provide all the affidavit of support, visa application, upload all the documents, all the good stuff. So it does take some time. If you're still not approved with USCIS, I would say you still have probably another 6 months, because after the approval with USCIS, they have to transfer the case to the NVC. Then the NVC sends you the portal. Then you do all of that uploading and paying the fees and all that good stuff. And then they review it, which takes about a month. Documentarily qualify you if everything good. If something is not good and they want more, then they will send you like a month later saying, hey, we need additional documents, or you don't have enough money, or something like that, to sponsor, to petition for someone, whatever the case is, right? But if they do documentarily qualify you, then they transfer the case to the local U.S. embassy, which also takes time, and they take time to schedule those interviews, and then there's medical examination, so there is some time. But as for now, one recommendation that I can make is, if you look at the processing times, and I will actually show you how to do that, and I'll use it as a demonstration for everyone who's watching. If you go to the official government website for U.S. Citizenship and Immigration Services, uscis.gov, we're going to click on Tools, and we're going to go to Case Status Online, and I know you already know how to do that because you checked, and it says Case Actively Reviewed. Actively Reviewed means still just sitting on somebody's desk, which is really sad, but you already checked that. So I want you to go and check the processing times for the case. And you do that on this page right here, I-130. So you're going to be U.S. citizen filing for spouse, and then whatever service center you sent your application to. Whether it's California Service Center, I think California Service Center is showing 15 months. So if, let's say, for example, you're in California Center, for example, and you already wait 15 months, and it's showing standard processing times 15 months. As you can see, this is 80% of the cases, 15 months. So that means that 20% cases take either less time or more time. So usually I recommend people wait additional 10% of this. So if it's 15 months, wait another like a month and a half. And if nothing happens, then on this same page, if you scroll all the way down, there is this link right here which says inquire about a case outside normal processing time. Click on that, you will have the form, fill out the form. Obviously form number is going to be I-130, form probably subtype, let's see what's going on. I-130 subtype is going to be U.S. citizen filing for spouse. There we go. Receipt number, all the information, and then submit it, just to give them a little bit of a nudge saying, hey guys, what's going on? And that kind of gives you, it opens the door for you if you further want to either submit a complaint or anything along those lines. They will ask you regardless, well, but have you submitted an inquiry about your case with USCIS? And if you did, then you can just say, yes, I already did that. Okay, let's move on to the next question coming from Abdullah Suleiman. My application is currently at NVC after I paid the fees. My visa class converted to F1 because of the naturalization of the petitioner. I also received a message in the CAAC portal asking me if I want to opt out the conversion of F1 and remain in the F2B preference category. Priority date June 2017. Should I opt out? Thank you so much for the explanation. You're very welcome, Abdullah. Thank you for your question. It's a great question, and I'm actually glad. It looks like NVC is on top of your case, and it's really good to know. It's really good to see that, okay, that they're following up at least, because most of the times petitioners or beneficiaries, whoever is more involved with the whole procedure, most of the times they have to send themselves requests to the NVC and say, hey, the status changed of the petitioner, can you please update the status? and then they wait and wait and wait until NVC reviews it, and most of the times they don't even update it, so it processes with the old status. So in your case, as you can see, they were on top of your case, and it's really good. And yes, I would not opt out of that, because F1 obviously has more priority over the F2B, and it goes by the priority. It's literally, that's what it is. You have F1 top priority, then F2 priorities, F2B and F2A, then you have the F3 and then F4, and in order it's the priority. So it's not just the random numbers, it's the priority numbers. So they will bump you up in the priority, which is, it's a good thing. Now, don't get me wrong, it does not mean that you will be processed much faster compared to the F2B, because both of the categories, they're experiencing delay right now with the backlog and the artificial backlog that we had from the pandemic, but nevertheless, it's definitely better. So I would not opt out, and yeah, looks like everything is going good with your case at the NVC. All right, let's move on to the next one from Lolo Natis. Lolo Natis, thank you for another question, and also appreciate you being publicly subscribed to the channel. It means a lot. Thank you, you're very welcome. Understanding the April visa bulletin more. My question is, do I get visa form I-551 to travel and wait for final action to get green card, or final action date must correspond before you even get an interview? Excellent question, Lolo. I'm glad you asked that. So whenever it comes to the final action date, the final action date, it refers to being documentarily qualified with National Visa Center, with the NVC. Once you're documentarily qualified, basically it means that you meet all of the requirements for the visa. So if the visa is already available for you, really all you really need to do is just go for an interview. Well, there's a medical examination too, but you go for an interview. If you are in the outside of the United States, whatever local US embassy there is in that country, you go there for an interview and you get that immigrant visa, which is that form I-551 that you are referring to. So with that kind of I-551, you already have technically the permanent residence. Once you get it in your passport, that's it. It activates as a temporary permanent resident card once you come into the United States. All right, so you have that stamp. It serves as an immigrant visa, but once you enter the United States and you get the CBP stamp, Customs and Border Protection, just passing through the airport, like the normal procedure that they do with every passport that you give them. But specifically with the form I-551, once there is the stamp in the passport indicating that you entered the United States, the form I-551 converts into the temporary permanent resident card. And it's just a matter of I think it's 90 days after the arrival into the United States, you get the actual card, the plastic card, the green card. But yes, so the final action dates refers to being documentarily qualified, and all of that is done before the interview, before the US embassy interview and the medical examination. So let me do that, and we're gonna move on to the next question from Tekvan Im, or I am. For form I-130, how many years does it take to get an immigrant visa? Okay, great question, Tekvan. I answer a lot of questions like this, so I'll definitely gonna need you to follow up. Please, separate comment. Don't respond to this comment here. And what I need to know to give you very, very rough estimates is the category, right? So who is petitioning? Is it US citizen? Is it permanent resident? Who they are petitioning for? Spouse, brothers, sisters, maybe if a US citizen, or parents, maybe children, over 21, under 21, married, unmarried. Also, from which country? Not necessary, but it will help in case if there is a visa cap, because in visa bulletin, it goes, there's 5 different chargeability areas, but 4 countries that have their own separate chargeability area. And they are a little bit of a slower processing, not really slower processing, but they have a little bit more of a delay, backlog, whenever it comes to the availability of the immigrant visas. And also knowing where you're filing from here in the United States, it would be helpful. Why? Because depending on which processing center, USCIS processing center your application goes to, again, it will vary. The time frame will vary a little bit. Okay, let's move on to the next question comment from D. Hi, I update my address online, but still haven't received a mail for this, and it's been over a month. Although I did receive an email request confirmation the day I updated online. Okay, great question, comment D. Whenever it comes to the address change, usually it does process very, very quickly, like a week or 2 weeks. But honestly, considering the condition that USCIS is in right now, with the delays, like literally, I really don't know anybody or any kind of whether it's a petition or application that is not experiencing a delay and somebody's, oh yeah, it's being processed without any problems. So I wouldn't be surprised if they are, delayed on the processing of these address change requests. On the plus side, you did get a confirmation, at least in the email. As long as everything looks good, you did your part. All right. So now it's all on them. But you submitted, your address change request. So, and you got the confirmation that they received it. So it's done on your part. Just hopefully they'll get around to submitting it. So let's move on to the next question comment from Oswin. DSA Oswin, thank you very much for being publicly subscribed. Appreciate it. Thank you for responding to my previous comment, and thank you for good work you do. Thank you. Appreciate it. Appreciate your comment. Apologies. No need to apologize for nothing. I should have provided more information. That's all good. No problems at all. I'm legal permanent resident, and my wife is currently in US. There's more. Valid F1 status. Okay, so all right, so that's a student visa F1. I wanted to file I-130 and I-485 concurrently. Based on my understanding, the visa needs to be available to file concurrently for spouse of LPR. The recent visa bulletin update, the final action date for F2A went back a few years, yes. So can I still file I-485 along with I-130 based on date of filing graph? Or I need to file a petition I-130 and wait for priority date to be current on the final action date graph to file the adjustment of status. Also, thought there was visa cap for F2A. Is my understanding wrong? Thank you. You're very welcome, Osman, and no need to apologize for nothing. Thank you for the follow-up comment. I really appreciate it. So yes, you're 100% correct. There is a visa cap for the F2A. The thing is though, with the F2A, because there was a much higher availability of the immigrant visas, and also there is an exemption. If you look at the visa bulletin, there is a 75% exemption for whenever it comes to the per country limit, unlike any other category. All right, which makes the second priority categories for especially the F2A. That's why you would see them always current for the most part. And now they're not, unfortunately, as of April 2023 visa bulletin, and that's really not as much as because of the backlog that is associated with the limit, that is the cap, because the cap on this is, when you compare it to other categories, is pretty much insignificant. That's why it was always current, because however many applications they would receive, a lot of times they would either fall in the 75% exemption for per country limit, or it would from the other unused categories that they would utilize the visas that would be available. That's why they were current. And now they're not, because we got that artificial backlog that was caused by the whole closures and everything during the pandemic. So yes, you are definitely correct. There is a cap on F2A, and as far as your question goes, filing the I-130 and I-485, if the visa bulletin did not change in April, I would say go ahead and file both of them together. But because of this situation, because of what we're seeing right now, I don't want you to take a risk and send, because you're paying for the I-130, you're paying for I-485, and you don't want to submit that payment and then your application is denied and they say, oh, because the visa is not available according to the visa bulletin. You don't want to be in a situation like this. So as of right now, I would recommend just filing the petition I-130, and I would recommend doing it as fast as possible. And then once you get closer to the processing, the NVC, once your USCIS, the petition is approved with USCIS, you will still get because in the in the petition, in the I-130 petition, you will specify where the beneficiary is, and you will specify that she is here. So once the petition is approved with USCIS, NVC will ask you regardless whether you want to have it processed with them, with, you know, through the US Embassy, if, you know, by that time she's outside of the United States, or if you want to just file the form I-485 here in the United States. And if she's still here, then yeah, obviously just do it then, do the I-485 later. But as of right now, really there is no benefit filing it together. There's just a risk, and the only reason why there is this risk is because of the situation of the most recent, just now as of April 2023, which is not even April yet, it's still March, but we know the numbers for April, and we look at them, and yes, there is now about a 3-year delay on the F2A category, which is really sad, really sad. But I would recommend filing the I-130 as soon as possible. The sooner you start the process, the better it is. Obviously, you know, I probably already mentioned it, and you probably heard me already say it, but file it online. It is available online, file it online. Anything is available online. I would recommend filing it online because it just saves time. It does save money too, because you don't have to mail anything, and obviously time. This time is one of the most precious things whenever it comes to the immigration process, just because the things take forever. All right, let's move on to the next question from Catherine. Hello, thank you so much for your help. You're very welcome, Catherine. Thank you for watching and asking questions. I would like to know that if I want to submit unsolicited evidence online for I-130 marriage-based form, do I have to submit that evidence like separate documents? Let's say one of bank statements, other for pictures of me and husband, insurance of our car, etc., or do I have to upload all of that in one single document? And can that be like a PDF document or documents? Thank you. And talking about pictures, how many pictures do you think is enough? Great question, Catherine. So whenever it comes to the USCIS, processing with USCIS, the petition I-130, initial start, right, of the petition for the alien relative. Whenever it comes to filling it out online, and my personal experience with filing the form online, it was probably about like a year, maybe year and 2 months ago. So it might have changed because I haven't logged into my personal USCIS portal. But whenever it comes to the documents, what it was before a year, if they haven't changed anything, what you have is once you're done with the application, it takes you to the documents upload page. And then you will have some of the required documents like marriage certificate. And it will actually say, marriage certificate, separate upload window. So you upload the marriage certificate there. Then you have the financial documents, can be bank statements, tax returns, tax transcripts. For those, right, because marriage certificate, you're going to have one page. Maybe JPEG or PNG or PDF, it doesn't matter, however your file is saved. But for, like, for example, bank statements, you might have, 20 pages of, bank statements. For those, if you can get the PDF, one file with all 20 pages within it, that would save you a lot of time. It would make it much easier because you're just uploading one file and it already contains 20-30 pages. And that's good. That you can do. Now, whenever it comes to the pictures, and I know here you're specifically referring to the pictures that establish the relationship between you and your husband. And whenever it comes to those pictures, there is not a requirement on USCIS side on the I-130 petition whenever it comes to pictures establishing the relationship. Because for USCIS, it's mostly documents, right? So you have birth certificates, you have marriage certificates, birth certificate, birth certificate, obviously, whatever other identifying documents, they show your identity, and then the marriage certificate shows the relationship between you and your husband, and that should be sufficient for them. Pictures usually come into play whenever the beneficiary goes to the interview at the US Embassy, or if they are being processed here whenever they go for their interview to a local field office, the immigration USCIS field office. That's when, if they have any doubts, if they suspect anything, that's where it's good to have pictures and say, yeah, sure, of course. Do you want to see pictures of me and my husband in a vacation, or in the Bahamas, or in the whatever, or or our wedding anniversary, or something? Sure, there you go. But whenever it comes to submitting the initial application, you really don't need to worry about that. Mostly it's just the documents, and you will actually see, again, if they didn't change anything, I hope they didn't, but once you are done with the application, you will see, it will tell you specifically which documents they want you to upload and submit. Be prepared. It might be a little bit of a headache. I remember whenever I was dealing with, especially with the NVC, USCIS wasn't that bad, but the NVC, you upload a PDF of 20 pages and they want it in one PDF. That's the thing. They want the PDF document. They want it within one document, not separate documents. But then they limit the file size. And it's like, what am I supposed to do? Is you want all that, all the statements, all the bank statements in one PDF document, but then you put the size limit. So you would have to find a way to convert the PDF to maybe like rescan it in a smaller resolution. So be prepared to deal with that, some of that annoying technical stuff. Just kind of a heads up. But yeah, I hope I was able to answer your question. All right, let's move on to the next one. Yo, boy Martin, you're the best, man. I'm definitely far from the best, but I appreciate it. I'm glad my answer was helpful to you. All right, moving further to Enzama Dennis. Enzama, thank you for another question. Appreciate it. How can I change my B2 status to employment category while I'm in US? Great question. So B2 is a visitor for pleasure, visitor for tourism, visitor for pleasure. It's a regular non-immigrant visitor visa. All right. Once you come in here, you can, in fact, convert it. And there are a couple of things that you can do whenever it comes to the employment category. There's a non-immigrant employment visas, and there is also immigrant-based employment visas. So you will have to decide which one is what, and which one is, the process is easier to do, which one works best for your situation. If we are talking about the non-immigrant employment visas, like for example, non-immigrant visa, like H1B, I believe that would be the popular non-immigrant employment visa. You would have to submit a form I-539 application to change or extend status, and in your case it's going to be change status. So you will be changing from B2 tourist to a work visa. Or if you have, and I know you have in your situation, I think your uncle, if I remember correctly, who owns a business here in the United States, who wants to hire you, they can petition for you. So like we are talking about with all the people asking about the I-130 as alien relative petition, what your uncle will be petitioning for you is going to be a little bit of a different, and it's going to be, I'll show you forms, all forms, and we're going to scroll down. We'll find I-130 because that application is right there together with I-130. Where is it? Where is it? Why I can't find it now. Okay, let's do it. I-140. There you go. Immigrant petition for alien worker. That's it. That's what you want to look into. And your uncle, honestly. Your uncle mostly. Not even you, mostly your uncle. Why? Because your uncle would be the petitioner and he would be filling out this form and filing all the documents and showing all his bank statements and his business information. So most of the stuff, most of the work that has to be done in order to make this possible, it rests with your uncle. So he will have to deal with it. So I would talk to him, and I would offer him a couple of things, because he can, if he's sending you a simple invitation, right? He can say, hey, Enzama, come over in a letter. I'm inviting my nephew Enzama. My name is blah blah blah. I want him to come here, visit the United States of America. With an invitation like this, you would go to U.S. Embassy and you would get a visa like B2. All right, because you're just visiting. But once you come here and he, you guys meet and he wants to hire you as an employee of his business, then two options: either form I-539, and it's the change status, again, non-immigrant work visa, or a little bit more of a complicated process, but obviously a little more rewarding, I-140. All right. So as always, I hope I was able to answer your question. I'm going to pause this and we're going to move on probably to our last question for today from Melisande W. Got two I'm well past my 180 days and 150 days. Oh, okay, indeed, both fingerprints for I-765 Asylum C8 category. Last update was October 2020. Hi, sir. Keep up the good work. Thank you. I appreciate the follow-up comment. So you should be good. In that case, you should be good. If you're past the 180 days, then you're definitely good whenever it comes to the employment authorization document. So I'm not even gonna bother you with your comment has been answered in this video because everything is good on your end. All right, let's see if we can address just one more. Hi again from Jamaica. My priority date from Simone Williams. Hi again, I'm from Jamaica. My priority date is June 26, 2017. The last update I got was summary information. Any idea how long from now will I receive a welcome letter? So let's see. So from Jamaica, priority date is June 2017. So that's in all chargeability area. I got a summary information. Any idea how long from now? Okay, Simone, I'm gonna ask you to please provide a follow-up comment with additional information. I need to know which category that you're referring to. So is it a U.S. citizen or is it a legal permanent resident petitioning for beneficiary? And who is the beneficiary? Is it, spouse, child, or parent, or brother, sister? Let me know and I would be able to give you a little bit more information. So thank you everyone for watching. As always, thank you all for your questions. As always, as many additional questions you have, do not hesitate to post them. It's not too many questions is not a problem for me, because I will get them eventually. If you're patient enough, I will get to them eventually. All the questions are welcome. Why? Because if there wasn't any questions, then I wouldn't be able to make these videos. And if you find these videos helpful, then that's it. That's a blessing for me. So thank you very much for watching. Appreciate your time. God bless, and I'll see you all in the next video.